Hello and good morning and good afternoon to our friends on the West Coast, East Coast. This is Meg Pekarsky. I co-chair the Hospice and Palliative Care Practice Group here at Reinhardt. And I'm so glad so many of you could join us. I think we're going to have over 220 sites on today's call. I have my friend and colleague Heather Fields, who has been heading up our HIPAA initiatives here at the firm. I invited her to talk to all of our hospice friends and clients about practical considerations related to HIPAA. And our approach in this session is really to not provide a panicked approach, but really as we come down to the last month before the compliance date, what are the key things you need to be doing? And so I wanted to give an overview of what we're going to be covering today. So hopefully by the end of today's session, you should know what should be on your list of things I need to get done in the next month or so. So with that said, we're going to first cover the Notice of Privacy Practices. And what changes you may need to make to that document, and answer questions you may have about do I need to redistribute that notice and those types of things. Then we're going to talk about a very important topic is who is your business associate? And the definition was expanded, and we're going to talk about what that means for your business. The liability for business associates has also changed. But we're going to give you some practical tips about deciphering who and who is not your business associates, because in working with hospices all across the country, one of the things we run into is that a lot of people think that there are people who qualify as business associates that actually you may not need to have a business associate agreement with them. Then we're going to briefly talk about breach notification, because there were also changes here. And so when you have a breach, your obligations about when you have to report that to patients and what other reporting obligations you might have, we wanted to make you aware of those. And then we're going to talk just a little bit about fundraising and marketing, and also individual rights as it relates to deceaseds and who we can give information to after someone dies. So with that said, I want to turn it over to my colleague Heather Fields to dig in here. As you saw in the beginning slides, we're going to leave a few minutes at the end for questions. And there's instructions about how to pose questions, so please refer to those. And then also at the end of today's session, we're also going to be sending out a survey to those of you who have attended. And if you could give us feedback not only on the presentation, but also we wanted to get ideas for other topics you might want to hear about. We are going to be doing something called the Hospice Minute, which is going to be an email that we send out to hospices that is going to alert them to changes in law and practical considerations and things you might want to be thinking about, just all things hospice. And so any ideas you have that you'd like us to cover in the Hospice Minute would be greatly appreciated. So with no further ado, Heather, take it away.
Thank you so much, Meg, and it's really my pleasure to be here this morning with all of you. I think that there has been a frenzy of activity that I've seen in the last month among various internet articles, as well as calls from clients feeling a little bit panicked about the fact that September 23rd, which is our key date here, our compliance date, is fast approaching. And as Meg mentioned, our goal here today is to provide you with some very specific to-dos in order to ensure that you are in compliance by September 23rd. I think for those folks who are just starting to sort out what needs to be done, there will be some implementation specifics that you're going to have to address after the 23rd, but I will tell you, given the complexity of many of these changes, I think it is true for almost all of our healthcare provider and covered entity clients, as well as business associates, that folks are going to be sorting out implementation of these requirements for some time to come. Look at the key dates, and each of these has significance. The rule was published on January 25th, 2013, and these regulations actually, it's called the Omnibus rule because they basically put together 4 rules into one. They made some changes and clarifications to the breach notification rule, which was published back in 2009. They made some changes to the privacy rule. They made some changes to their instructions, and they also issued regulations implementing GINA, which is the laws protecting genetic information and discrimination against individuals on the basis of such information. We're only focusing today on what you need to do to comply with the breach notification and privacy rule changes. It's important for you to note that there have been no changes to the security rule. It remains fully in effect and it is unmodified. In terms of your immediate steps, I'm going to start with a list of things I think everyone needs to be really focused on over the next month. And then I will go into detail on how you need to address these. But your key documents are first and foremost your Notice of Privacy Practices. And the reason why that is so critical is that it's a very public document. So your website likely has your notice posted on it. It's something you're giving to all of your new patients. And it's a very easy item for anyone to verify whether or not you have implemented the changes. So I think that that would be a high-risk one to focus on immediately. Second, and not far behind, is your business associate agreement that you are using with your business associates. We're going to talk about this a little bit later, but the good news for most of our hospice clients is that generally speaking, hospices have a fairly limited array of business associate relationships. Even though the definition of business associate has been expanded, I think most of you will have a shorter list than some of our other institutional clients in terms of making sure new business associate agreements are executed. Third, your breach notification policy and your related forms that you use. This is a very critically important document simply for the fact that as of September 23rd, you will need to be applying a new standard when you have an unpermitted or unauthorized use or disclosure of PHI. It's going to look very different from what you had previously. So it's going to be particularly important with respect to this breach notification change that you have really done your best to implement that on or before the 23rd. And then, of course, you are going to have other policies and procedures that are going to need to be updated to reflect the changes to your privacy practices and possibly also your procedures for dealing with businesses. I think that I would certainly make that a lower priority because what's really critical are these other 3 steps. Without further ado, let's dive in and talk about the Notice of Privacy Practices. Not an exciting document. Everyone on the call, I am certain, has seen one. You've either received it as a patient yourself or you have helped draft the notice for your organization. Some of the additions are just intended to ensure that individuals are really clear about how their information can be used. And what the government wants is to make sure that uses and disclosures that are requiring authorization, and I gave you the example of sale of PHI, but this would also include categories of information that are particularly sensitive, like HIV or other communicable disease status. You need to identify in your notice very specifically that your organization will not be using that information without the prior authorization of the patient or their legally authorized representative. You also need to add to your notice that folks are going to have the opportunity to opt out of receiving fundraising communications. Most people had something in their notices previously, but we're going to talk about how that has changed a little bit. You need to have a statement that very simply says, you will be notified if there is a breach of your unsecured PHI. It's just that easy. It's not that complicated. You just need to have a statement in there that says that. Many people had already updated their notice in 2009 when the breach notification rules came out. However, there are a lot of folks that did not. So now's the time to add it. Last but not least, it's important, even though it likely won't apply to many of our clients, it's required that you indicate in the notice that if an individual pays out of pocket for their treatment, they have the right to restrict disclosure of the PHI related to that particular episode of treatment for which they self-paid to a health plan. Let's talk a little bit more about fundraising. You have to make sure, as I mentioned, that you identify that you can opt out of receiving fundraising communications. And almost all of our clients, healthcare provider as well, as well as hospices, engage in some fundraising activities. The opt-out mechanism has been clarified, and HHS has made it very clear that it cannot cause the individual to incur any kind of burden or more than nominal cost. And so what's out the door is requiring individuals to write a letter or put a stamp on a postcard. That apparently is more than a cost in the eyes of HHS, and they have encouraged, now make sure you understand that doesn't mean require, they have encouraged the use of a toll-free phone number or so you can do either one, an email address. These are means by which the government has deemed you can allow an individual to opt out without incurring any burden. I will tell you most of our provider clients are using a local phone number. I don't have too many clients that are using a toll-free phone number, but I wanted to make sure that you were. Next, distribution of your privacy practices. This is one that gets a little bit confusing for folks. And the reason for that is that previously some organizations indicated in their notice that if there were changes made to the notice, that individual would be notified. And that was sort of unfortunate that many people did include it. I certainly understand the advocacy behind that. You want people to keep apprised of how you are using their information. Having said that, it can be quite a burden to have to go back and notify former or current clients by paper, with a mailing, that your notice has been updated. So this is one where you need to actually review what your current notice says, and if it says you're going to give a copy, if you update it, then you got to do that. However, if you were lucky enough to utilize a notice form that did not say that you were going to issue a notice, then all you need to do is post your new have a physical facility, or if you don't have a physical facility, just have the new notice immediately available for patients on or after the effective date of the change. And obviously that needs to be by September 23rd. This means that you need to make sure that members of your team that are going to be visiting patients have copies of the notice available to give to those patients. And I don't think it would be a bad practice simply to provide it to them on your next face-to-face encounter with that patient. Having said that, that is not required. You are required to provide the new notice immediately to new patients, and you are also required to get the acknowledgement that they have received that notice of privacy practices for new patients. But for your existing patients, you do not need to obtain a new acknowledgement. That's something that caused quite a bit of confusion for some of the folks that we've been working with. Let's turn now to business associates. This is a really big deal, and it's sort of something that isn't, I think, immediately obvious. But there's a couple of things that are going on here. First and foremost, the definition has been expanded to include all entities that create, receive, maintain, that's a big change, or transmit PHI. And so OCR made really clear here that anyone who maintains your PHI is going to be a business associate, even if they don't have frequent or routine access to the PHI. So for those people who remember when we had paper records or are still operating with paper records, any kind of document storage company that maintains boxes of files is now going to need to be a business associate, whereas previously those folks were generally not considered to be business associates because their access is either nearly non-existent or the possibility they would access it is fairly remote. The other big expansion, and this is huge, is that the subcontractors of business associates now are also directly subject to the requirements of business associates under the privacy rule. That means also that they're going to have to comply with the breach notification provisions as those relate to business associates. And that is a really big deal for business associates that utilize a lot of downstream subcontractors to perform services. I think that this will be a particular issue when you are dealing with consultants, whether they be clinical consultants or other financial, billing specialist consultants who might utilize independent contractors to provide you with services. This is going to be a big expansion. And you might say to yourself, well, why do I care so much about that? Well, the other key change is that the government made it very clear that both covered entities and business associates can have vicarious liability for their agents. And I'm going to talk for a minute about what I mean by that. Covered entities can be liable for the acts of business associates who are acting as their agents. Now, very unhelpfully, the rule says that agency will be determined under federal common law. And what that essentially means is that whether or not an agency relationship existed is really going to be a retrospective determination based solely on the facts and circumstances of the relationship that you as a covered entity might have had with that business associate. So it's going to be determined in hindsight. So I think that that means that when you're dealing with folks that are going to be utilizing your PHI or having access to it, storing it for you, really need to be thinking very carefully about whether and how they are protecting your PHI. I think it comes down to that quite simply. I think that the potential for vicarious liability will always exist because being an agent is really kind of a squishy term in federal common law. It really generally would deal with someone whose activities you control. And so, for example, an agency relationship would likely not exist with your lawyers like Meg and I. You don't control how we perform our services. We're furnished. Your accounting firm likely is not going to be your agent. Compare that with an independent contractor medical director who is acting as part of your team. Business associates also can have vicarious liability for noncompliance of their subcontractors, but because this is focused today on our covered entity clients out there, really we want you to be thinking about it vis-a-vis your business associates. I want to talk and back up for a minute to talk about business associate relationships generally, because we find in our practice that many people have difficulty determining when a business associate relationship exists. And I will tell you, it is sometimes tricky to sort out. But fundamentally, you really need to understand that a business associate is a party, whether that party be a covered entity like a physician or not, like a janitor service that's just going to empty the trash and clean the floors, or your landscaping service. So it's going to be an individual, could be a covered entity, that is performing a service on your behalf. A healthcare operations related service, maybe a billing service. It is not the case that two parties that are independently treating a patient are business associates of each other, because treatment relationships are an exception from the definition of business associate. So what do I mean by that? Let me give you a very clear example. if for some reason, and I know this is not common, but a hospice were need to arrange for a consultation with a specialist physician, say a cardiologist for some reason, for one of their patients, that consulting physician might do so under a contract with the hospice, likely would, and might be actually their services might be compensated through the hospice. So the hospice might pass on reimbursement to that physician for the service, depending on the circumstances. That individual is treating the patient in their own independent capacity as a healthcare provider. They are not your business associate. They're providing treatment only. So where someone is doing treatment plus administrative services, that's where it gets a little bit trickier. And I'm going to talk about medical directors. I'm sure all of you are just sitting there with bated breath because it's a really exciting topic, but we're going to get to that in just a sec. The one thing I want to also point out to you is another example, and I have it here in this slide 15. You, as a hospice, are often asked to sign business associate agreements when you are not a business associate. And a perfect example of this that we see all the time is the nursing home relationship. Nursing homes and hospices are not going to be business associates of each other, generally speaking. Unless that nursing home is providing some additional administrative service for you that is outside the bounds of what the typical relationship would be, you are not their business associate, and likewise, they are not yours. And that's really important. And you might say, why is it so important? It's this liability exposure that I'm very concerned about. When you agree to be a business associate, that's creating contractual obligations that you have to fulfill, and for which your failure to fulfill would give rise to legal liability potentially. You also have regulatory risk because business associates are directly subject to enforcement. And so you might say to me, Heather, I'm a covered entity. I already have to comply with HIPAA. And I would say yes. But if you're acting as a business associate to a party, that's just an additional avenue of liability that you could incur. So you're not only liable to the government for what you've done wrong, but now you're also liable to that party with whom you've entered into that business associate agreement when perhaps, and if you had not entered into the contract, you would have no connection to them whatsoever. It's also important to remember that the failure to enter into a business associate agreement when it's required can also give rise to liability. Simply put, you're not complying with the rule when you don't enter into a business associate contract when that is required. So a little bit, this chart is a little busy, but it's just to give you some select who's in and who's out examples. Your billing, clinical consultants, accountants, auditors, lawyers are all going to be your business associates. Nursing homes, independent attending physicians, consulting physicians are not. A pharmacy benefits management company with whom you enter into an agreement will be your business associate. A pharmacy itself, where all they're doing is providing you with medications, is your electronic health records vendor is absolutely your business associate, and that's a huge source of liability to you if they're maintaining records on your behalf. Your internet service provider or your telephone, your cellular service company is not going to be your business associate. Document storage and destruction companies are going to be business associates, whereas your messengering service is not. Now, you note I did skip over the medical director, independent contractor versus medical director employed or part of workforce, and that's because we're going to talk about that right now. So medical directors are a tricky situation because those folks may be serving as attending physicians for the patients. They are usually independent contractors. They might be employed, but often they are independent contractors that you have an agreement with, and it is really tricky as to how you appropriately categorize these folks. Now, you have two options that we recommend. There might be others, but these are the two primary options. One is to treat this individual as a member of your workforce. And for purposes of Reinhardt and our template documents that many of you have utilized, this is how we assume you are treating your med director. This is usually preferable as well, given the very integral role and the duties of a medical director. They are a member of your team. They're side by side with you, and they really need to be following your policies and procedures in the services that they're providing. We think that treating them as a member of your workforce also really reflects the level of integration that you are seeing to be required now vis-a-vis the billing rules that are being changed. And so folks really need to make sure that their medical directors are really in tune with what they're doing and what their policies and procedures are, and really integrated into the operations of the hospice. What that means in terms of your obligations are that you must ensure that that physician completes your training and follows your policies and procedures. Because they're an independent contractor, they likely have their own HIPAA compliance issues when they are dealing in their private practice. But when they come to treat your patients or to service your patients as in the role of medical director, they will be acting as a member of your workforce. And you are liable just as you would be any other employee for any of their acts or omissions. If they impermissibly disclose PI, if they don't follow your security policies and procedures, you would be liable for that. If they are a member of your workforce, even if they are an independent contractor, they do not need to be a business associate. Members of a covered entity's workforce are by definition are not members, are not business associates. So that's really important. If you're going to treat them as your workforce member, they're not going to sign a business associate agreement. Let's talk about the other alternative, treating them as a business associate and entering into a business associate agreement with them. Now, in some respects, this may provide some additional contractual protections if that physician is non-compliant with your policies and procedures or just generally with HIPAA. If you are going to go this route, however, your typical business is written assuming the person is an independent contractor and that they are going to have and follow their own policies and procedures. That is not what you want for your medical director. So if you are going to go the business associate route, you really need to consider whether you would modify your template business associate agreement to reflect that special relationship. In terms of your business associate agreements, I think it's critical that you rethink your document that you're using presently. And we're going to talk about the breach notification rule in a moment, but I already mentioned to you that covered entities now can be liable for the acts of their business associates. And breaches of PHI are a huge source of liability to covered entities. One of the things that business associate agreements already should include is that the business associate will be fully compliant with the security rule. However, I will tell you that most business associates may or may not fully comprehend what that means. And because you have such a high risk of your business associate losing your PHI, if they keep it unsecure in an unsecure, unencrypted format on a laptop and they lose that laptop, or the laptop is stolen, or they put stuff on an unsecure flash drive, or they're carrying papers and, God forbid, they get in an accident and the papers end up all over the highway. You might laugh, but I have been the recipient of the phone call where that has happened. And so it's critical that your business associates really understand, particularly with respect to electronic PHI, because that can be so damaging if it is put into the wrong hands. Really important that they understand how and what they need to be doing to comply with the security rule. So that would be using encryption, making sure that when you're done using the PHI, you wipe the portable media device, whether that's a laptop or an iPad or whatever, you wipe it clean. You put a magnet over that flash drive, whatever you need to do to make sure that that data is no longer out there. You also need to consider whether you might impose some limitations on the ability of your business associates to hire and utilize subcontractors when providing you services that require their use of your PHI. So what might that look like? You might change your contract to say, look, you won't use subcontractors unless you receive our prior approval. Maybe that's not practical for your organization. Well, you could add in language that would say, look, if you're going to use subcontractors, not only must they enter into the required business associate agreement that contains the same terms and conditions to which the business associate is subject with you, but maybe they're going to maintain a list of those subcontractors that they could provide to you upon request and keep track of what PHI each of those subcontractors have. One of the really difficult things is when someone calls me and says a laptop was stolen, I have no idea what was on it. That's really problematic because it makes it very hard for you to conduct your breach analysis and furthermore to figure out if you do determine there's a breach, how and who you are going to notify. So that is a really practical way if you don't have the ability to limit subcontractors to make sure that you can keep tabs on what's out there. One thing I want to make sure that people understand is that business associates always were required from the very beginning to provide notice of any non-permitted use or disclosure of PHI, even before breach notification came out. Most people didn't understand that, and I think they didn't understand it either because they didn't read the contract, because I may be one of the few people in the country that does, or it could just be that it doesn't make sense to folks when they're just doing their job that they should or shouldn't be looking at something. And let me give you a perfect example. The HIPAA privacy rule requires that both business associates and covered entities apply the minimum necessary standard when using PHI for healthcare operations. So, in your perfect example of an audit, you're going to hire a consultant to come in and do a clinical or a billing audit. The documentation they create related to that audit must comply with the minimum necessary rule. So if they create a document that has patient name, birth date, medical record number, and their findings, that could be fairly problematic because that violates the minimum necessary rule. In order to assess whether or not a claim was properly submitted or there was documentation for a claim, you don't need to know that it was a claim for Heather Fields and that she was born on XYZ date. That's not necessary. You just need to know what the claim number was, and maybe you could use my initials or some other non-identifying way. Give code it, use a number, and then maintain that code separately and in a safe place. That breach of minimum necessary requires a breach analysis, even though it's your business associate and even though they are doing a service that you ask them to do and which they are permitted to do under the rule. And that's just a perfect example of how most people are not thinking about how the notice provisions work. I also recommend that you make it very clear that you as a covered entity have a right to audit your business associate, meaning to request copies of their policies and procedures that document their compliance, to request a copy of their security risk assessment, which is a written document they're required to have to comply with the security rule. You'll be able to look at that if they, God forbid, lose the laptop or have the laptop stolen that has your unsecured PHI on it. You want to be able to prove when you notify the government of your breach or if you get investigated related to that, that your business associate was doing to protect that information. Retaining records of the efforts that your business associate has made to mitigate the effect of unpermitted uses or disclosures, very important. If you don't add an audit right or a record retention requirement in your contract, I can tell you it will not contain it. That is not among the required provisions that are set forth in the HIPAA privacy rule. Last but not least, I mentioned indemnification. We could spend an entire seminar talking about indemnification, so I'm not going to go in depth here, but I suggest that you do consider whether or not it is appropriate, and particularly in situations where it is a high-risk vendor for you. And I'll give you a perfect example of that. If somebody is maintaining your electronic health records on your behalf, and let's say it's a situation where they actually maintain the server, which means that all of your security rule or most of your security rule compliance is really being outsourced to a third party. You want to make sure that if there is an incident that you incur expenses to sort out. The breach notification analysis often requires you to hire legal counsel. You might have to hire computing forensic experts. That costs a lot of money. So that's a situation where you might want an indemnity provision in your contract. So a word on timing, and then I want a chance to cover some of the other important changes to the breach standard and other marketing, fundraising, and the CDI rules. New BAAs need to be in place by September 23rd for any arrangement, contract that you entered into on or after January 25th. So if on February 1st of 2013 you signed a new contract with an electronic health records vendor, you need to have a new compliant BAA in place with them by September 23rd. If you, let's say you had that contract with that vendor in place on January 1st of 2013, so 24 days before the rule was issued, that contract will be just fine as long as you had a compliant business associate agreement in place with them. You get an extra year. You get until September 22nd, 2014 to execute a new BAA with that individual. Bottom line, you are going to need to have new business associate agreements with all of your business associates. And the question will be, is it one I have to get done in the next month, or is it one that can wait until next year? And if you have any questions with that, obviously we're happy to help you sort that out. Okay, the new breach standard.
Heather,
Yes.
this is Meg. I just, because I've been following the questions that people have been asking, and before we leave the topic of BAA, just to close that up, because we've gotten several questions about, is a therapy company we contract with a business associate, is an assisted facility or group home that we work with a business associate, and the answer to that is no, unless that therapy company was doing some administrative. You said, geez, I want to pay you to review some of our patients, our census, and say, you know, what could we be doing better from a therapy perspective? Like, that never happens. I've never dealt with that issue. But if you're doing something to help the organization, that they might qualify as a business associate. But if they are just doing a therapy consult, meeting with the patient, and providing treatment, that is an exception to the business associate requirement, and you do not need a business associate agreement. And the assisted living and group home, like the nursing home as well, they are not providing a service on your behalf. And so they don't qualify as a business associate because they need to be doing something on your behalf. When you're two treatment providers that are both providing treatment and you're exchanging information for that purpose, you, the parties are not business associates. And so an area that comes up, and Heather's listing, I think, was very good over who are your most common business associates. You know, it's your PBM, it's your, you know, lawyer and accountant to the extent they get PHI. If you have a pharmacy consultant who is doing your drug reviews, that person is not doing that to treat the patient. They're helping you with an administrative regulatory requirement, and they would be a business associate. So, again, if you're doing general inpatient services or respite, again, that provider is not doing that on your behalf. They're providing treatment to that patient. You have a contract with them, and just because you pay them doesn't necessarily mean that they're providing, you know, a service on your behalf. We are sort of like managed care in the sense that we have to coordinate and pay for all the care related to the terminal illness. So the fact that you're paying someone does not mean that they're automatically your business associate. You need to say, well, in what capacity are we sharing PHI? Oh, it's so you can treat this patient and you can communicate with me about treatment of that patient. And so so I think that as Heather said, that list of true business associates is probably going to be, you know, fairly short. And as Heather said, I just want to reiterate, because it's really, really point is we really don't want to be signing business associate agreements with people who are not business associates, and because we could have additional liability for their actions. And I think if you try to get people to sign business associates when they don't really qualify, you're probably going to get more pushback from people because there is additional liability for business associates. So, you know, if you've said to a nursing home, here, sign this business associate agreement, in addition to not really being a business associate, probably going to question that more now too, because they're like, I don't want to assume additional liability. So I just wanted that brief summation there, because that's what I think all of our questions have been on. So Heather, sorry to interrupt, but back to the breach.
Not at all. And apparently another question came in related to business associates about whether student interns are going to be business associates. And, you know, what's really interesting is I get clinical training, clinical training site agreements all the time from our provider clients to review, where the school will sometimes ask for a BA, or perhaps our client will be asking for a business associate. I will tell you that, generally speaking, students are never going to be your business associate. You are providing a clinical training experience for them, and they are not performing any service on your behalf whatsoever. They are members of your workforce and should be treated as such. Healthcare operations includes training and education activities. So you are acting in the scope of healthcare operations when you provide that clinical training experience for that student intern or what have you. And so you're not creating a business associate relationship. That doesn't mean you don't need to make sure that person's been trained, follows your policies and procedures, and is safeguarding PHI, but they're not a business associate. So I want to touch on, we have about 15 minutes left, and I want to touch on the new breach standard. And you'll forgive me for putting a picture of the screen here, but this is something that I think is really was not anticipated by the government to really be as a negative impact on folks as it will be. So let's talk about why I'm concerned about it. So August 24th, 2009, breach notification rule issued, requires covered entities to give notice of breaches of unsecured PHI to individuals. It also requires business associates to notify covered entities of breaches. Now, I want to give you a word on this. This doesn't mean, like I mentioned to you, your business associate, a breach is a very specific category of an inappropriate or unpermitted or unauthorized use or disclosure, okay? It's its own separate special category of that. There are lots of unpermitted uses and disclosures. I gave you a quick example of one of the audit, okay, where you are using PHI in a non-permitted manner. Maybe you're using more PHI than you're required to. That is something that business associates have always been required to notify you, but most people didn't think about that until the breach notification rule was published. So the rule itself was modified slightly in the Omnibus regulations, and specifically, you've seen this definition before. Breach is the acquisition, access, use, or disclosure of PHI in a manner not permitted by HIPAA that compromises the privacy or security of the PHH. And this requires a little bit of breakdown there. As I mentioned, in a manner not permitted by HIPAA would include violation of minimum necessary. And that's something they explicitly discussed in the preamble commentary to the rule, because most people that never crossed their mind. So now it needs to. And we've got that word compromise. It compromises the privacy or security of the PHI. Right then and there, you know there's going to be a judgment that is applied to figure out whether or not you have a quote-unquote breach. So here's a little crying baby. Here's where the rubber hits the road. Under the interim final rule from 2009, there was no breach unless you found that the non-permitted use or disclosure posed a significant risk of financial, reputational, or other harm to the individual. So it was this risk of harm to the individual, very subjective. And I had clients come down differently on various types of common breaches. Some folks, for example, where PHI was emailed, some people would treat that as a breach if the email was unencrypted. Other folks would say, no, we're not going to treat that as a breach because we don't think there's significant risk of financial, reputational, or other harm because we emailed the document to our accountant, the claims information to our accountant or our auditor, and we know they received it, and we don't believe that there was any untoward, activity with respect to the PHI while it was being transmitted over the internet. New rule, okay? This is a new world with breach. It is presumed. Presumed means unless you prove otherwise, it's a breach if it's a non-permitted use or disclosure of PHI. So unless you prove otherwise, your violation of minimum necessary, whether internal or external, is a breach. Presumed to be a breach unless you demonstrate there's a low probability that the PHI was compromised. Low probability. So you went from having to find that there was significant risk, subjectively determined is there significant risk, and now you're left with I've got to prove there's low probability of compromise to the PHI. And you might say to me, Heather, what does compromise mean? And I'm going to come back to this slide. What compromise means is that you have looked at these 4 factors and documented that to see whether or not the PHI has been compromised. I will tell you that if something poses a significant risk of financial, reputational, or other harm under the old standard, that is compromised. Okay, that's going to be compromised. However, what OCR says now is, okay, well, if you're going to figure out compromise, you've applied these 4 factors, and you must document. That, when I say document, I literally mean you've got to have a form where you write for each and every one of these factors what you found. If you want to determine that there is no breach. So these are the 4 factors. Let's just talk about them briefly, and then I want to talk a little bit about what I want you to do to address this. So note 2, if I can pause for a second, note that your current breach notification policy probably contains the prior language that you will assess whether or not there's a significant risk of financial, reputational, or other harm, and if there's not, there's no breach, and if there is, there's a breach, and here's what you'll do. You got to change your policy. It's completely different now. Now your policy is we will presume there's a breach unless we can determine and document that these 4 factors demonstrate that there is a low probability that the PHI was compromised. I will grant you that this is something that makes my head hurt, and I think it's much more complicated than the government puts out. Having said that, these are factors that likely would have been considered vis-a-vis the risk of individual harm standard that was the old standard we lived under. So I think a lot of people have been evaluating these factors, but now this is how you're going to determine compromise. Nature and extent of the PHI involved. What was it? Was it just a simple, medication refill, notice that you sent to the patient, or was it, something related to their HIV status? Second factor, persons who used the PHI or to whom it was disclosed. Did you send it to an attending physician by accident when it was, Mary Smith needed to go to, Dr. Pekarsky instead of Dr. Fields, and you sent it to Dr. Fields? Really simple kind of error that happens all the time. Well, doctors are required by law, they're covered entities, they're required to keep the PHI confidential. If instead you sent it to your, your book group mailing list, email group, that's a problem, especially if you're in a small community, which many of our clients are, and people might know that person. Third factor, whether PHI was actually acquired or viewed. I will tell you, I think this can be very difficult. If you actually have the luck of getting the stolen laptop back, you can hire someone that will be fairly expensive to assess whether or not the PHI was acquired, downloaded, or viewed. Another example might be the simple envelope. Someone receives an envelope from your hospice that has some information in it, and they say, hey, I have no relationship to this hospice. That must be the other Mary Smith in town. I will tell you personally, There is another woman with the same name as me, including the same middle name, so her name is exactly the same, and she was born in the same year as me. I frequently have received her information over the years. If that person returns the envelope unopened, you're golden. You proved up this factor, and you can say, hey, PHI was never compromised. The envelope was never opened. This is an example. Fourth factor, extent to which the risk was mitigated. Here, what the commentary indicates is you might say to someone, look, you got Heather's PHI, you sent it to Meg. Could you please write me a letter that says that you immediately destroyed it and you never looked at it? I'm not joking, I wish I was, but this is what they suggest you do to prove up that the risk was mitigated. Obviously, if the laptop is returned and you can prove PHI was not accessed or acquired in any way, then the fact that you make sure that in the future you've done something to make sure that no one can use it. So for example, if they take a smartphone, there's the ability now to wipe those clean remotely. Let's say you did that, and let's say within an hour of your smartphone being stolen that had PHI in it, you triggered the wipe clean program, however the IT gurus do that. That would be a mitigation right then and there. So you've got those. One thing I want to add to the changes of breach notification, I kind of have hit hard on this minimum necessary issue, but with respect to limited data sets, it used to be that if a limited data set was sent to the wrong person or improperly used, it wasn't a breach. Now it's a breach like any other. So if you utilize a consultant that uses a limited data set to provide analysis for you, or someone who's doing some kind of a clinical quality review and uses a limited data set to do that, or aggregates data using a limited data set, used to be that you didn't have a breach risk with those sets. Now you do. Okay, so let's talk about what you do. Number one, as I mentioned, you update your policy. Number two, you educate your workforce. Number three, you make sure that, as I talked about in the business associate agreement, that you're protected in that regard. Or for those folks who are members of your workforce, like your medical director or maybe your student intern doing a clinical rotation, you've educated them about the critical importance to notify you if there's any oops that occurs. High-risk activities that are going to get you into trouble include using unsecure portable media devices to access, create, transmit, store PHI. So your smartphones, your iPads, your laptops, your flash drives. Texting and emailing PHI is a big no-no. That can get you in a lot of trouble. Not to mention the fact that if you are transmitting a critical piece of information back and forth via email or text relating to the care that is provided to the individual, how do you make sure that that ends up in your medical record and gets integrated into your medical record? So it may be creating other issues, other compliance and billing issues for you, let alone the risk that you are creating for yourself under HIPAA. Failing to encrypt laptops where there is PHI residing, I use the word residing, on that laptop, big issue. Failing to properly destroy or remove electronic PHI prior to disposal of a device, or if you are retooling it, revamping it, giving it to someone else. Most of you may have heard about that huge fine imposed against an insurance company that gave back a bunch of copiers they had leased without wiping them clean, and they estimate that the potential was that 344 some odd thousand individuals' PHI could have been stored on those machines. And since it was an insurance company, there was a concern that there was a lot of financial information like Social Security numbers that might be on those machines. So huge issue, and one that I think providers often overlook. Okay, we have just 7 minutes left, 5 minutes left I'm told. So we've got to go through this. I don't know how many questions we've received, but luckily, I can get through this fairly quickly. We've talked about the fundraising changes where you have to provide the opt-out. What I didn't say was that the types of PHI that can be used for fundraising has been expanded, which is good news for directors of development. at large organizations or the folks who are trying to come up with a mailing list for their annual fundraising drive. You can use demographic information, the name of the patient's attending physician, their insurance status. Many people don't like to send fundraisers to people who are either Medicaid or self-pay. And outcomes. If you have a family where maybe things didn't go the way that you had planned or they wanted, you probably don't want to be sending those people a mailing to raise money. So now you have the permission for your clinical team to share this and only this amount of information with your fundraising staff. You have to, as I told you, provide the opt-out, but you also have to have in place a management system to make sure that when people opt out, you don't send them additional communication. And that's one where I get concerned if you just give them the receptionist's phone number. You've got to make sure you're tracking that somehow. That's really critical. Marketing changes, I'm not going to go in depth here. Understand that marketing is not the same as communications a provider makes to their own patients related to items and services that provider or that hospice is furnishing themselves. So let's say you offer massage therapy to your patients. You can send them information on that massage therapy. Compare and contrast, however, if there's a company in town that does massage therapy and they ask you to send out a mailing to your patients about their services and they want to reimburse you for that. That is a no-no. You may not do that without authorization. Sale of PHI, the only thing to note here is its direct or indirect compensation. One thing I would mention, obviously people know, I think, that you can't sell PHI whether or not they buy you, a new printer in return for it or give you $100. You can't do it. But one point I want to make to you is that if you use consultants that are providing any kind of broad-based data aggregation services or some other type of service where they have access to large amounts of your data, be very wary of permitting those people to keep your data after the contract has expired or they're no longer providing services to you. Many times they will say, we will de-identify information. And I want to point out to you what happens if they don't properly de-identify it. Well, that means they have your PHI, and that means they're using your PHI in a non-permitted fashion. So you need to be very careful that you are not inadvertently violating this rule. So, for example, if your pharmacy benefits manager says, we want to keep your PHI for data aggregation for our own purposes, and lo and behold, they're willing to provide their services for free in return for your data, that might be an example of where you might run afoul of this. Other than that, let's talk about individual rights for 2 minutes. And I just wanted to focus on deceased individuals to make it absolutely clear to you that HIPAA protects the PHI of deceased individuals for 50 years after their death. That means they have the same protections they did when they were alive. Now, there is a new exception that was put into the rule that is extremely limited and likely may not be permitted under state law, depending on your state. And we have a national practice, so we represent you folks coast to coast, so it's really important you don't think this applies to you when it doesn't. Basically what the rule said in the commentary is a lot of people complained that family members could not find out about the circumstances of a patient's death after the death because of HIPAA. And so they created this very limited exception to say, look, a covered entity may, it's permissive, so it doesn't mean you must. You may decide to disclose PHI, and what they're talking about really is communication. You may communicate with family members after the death of an individual. If that friend or family member has been involved in the care of the patient or payment prior to the individual's death, unless that individual told you don't talk to Aunt Sue. So let's say Aunt Sue came and visited them every week, she goes on vacation, you die, she calls you up and says, oh, I'm devastated, I really want to know, what happened, what transpired. It seemed like Heather was going to hold on a little bit longer. You can now talk to Aunt Sue and just tell her about the circumstances of Heather's death. What you may not do is give her copies of all of Heather's records or talk to her about any kind of unrelated treatment or condition unrelated to the death itself. That's what they are trying to do with this very narrow exception. And I will tell you, this has been the subject of a federal court of appeals decision in Florida. And so it's really important that you guys don't think that suddenly the law has drastically changed in relation to this. All right, I think we have 2 minutes left. Two questions. I have one that says, the example of sending PHI to the wrong doctor, is this now a breach? And I will tell you that it depends on the 4-factor test. Let's say that that doctor was an attending physician. You sent the wrong patient's information to that doctor's office. They let you know. They told you they destroyed it. They send you a little email. I destroyed that fax you sent me by accident. I put it in the shredder. I think that you could conclude in that situation that there is a low probability, if properly documented, that there's a low probability that the PHI was compromised. Okay, that would be an example where I'd say probably low probability. Compare and contrast that to you sent the fax to, a business, Pizza Hut by accident, and they received it. That's a big difference. And did you call them and say, hey, can we come and pick up the fax? Can you will you send us a letter that you wiped your fax machine clean and you shredded it, so you have in writing that the person did that? Maybe then, and then the other thing I want to point out is you need to know what type of PHI was it. Was it just an appointment reminder, or was it something that contains really highly sensitive financial information? Maybe it was something really that had their name, address, birthday, social security number, or other identifying information, their insurance card information. There's a lot of insurance fraud now. So that's what you're going to do to figure that out. I think that ends our time for today. We really appreciate you participating. Please let us know if you have any questions or concerns. And also, when you receive your survey, please let us know if you'd like to hear more about HIPAA implementation or other topics that we can help you with. Thank you so much, and have a wonderful day.